Appreciate it. And great to see so many familiar names here. For those of you who don't know me, I'm Ben Berkowitz. I'm a partner here at Keker Van Esten Peters, where I've practiced complex litigation for the last 20 years. So I have a pretty diverse litigation practice. My cases tend to involve emerging technologies. I would say over the last 10 years or so, an increasing portion of my practice has focused on privacy and cybersecurity litigation. And I am, along with my co-panelists here, Melissa, Lauren, and Spencer, I am excited that we're talking with you all today about AI and the new wave of privacy and cybersecurity litigation. For those of you who have attended our internet privacy and data security presentation in the past, we're excited for your feedback. We've completely revamped that presentation today to talk about what we're seeing now, which is this new wave of privacy and cybersecurity litigation stemming from the rise of artificial intelligence. And so welcome everybody, and we should have a nice discussion over the next hour. Melissa, or Spencer, could you move us to the next slide? So, like I said, I'm Ben Berkowitz. Oh, let's go back one. And this is with me today are Melissa Cornell, Spencer McManus, and Lauren Kane. I think before we get started, I just want to say, as you'll see in a few minutes, another thing that we're going to do a little differently this year is I'm planning to turn most of today over to Melissa, Spencer, and Lauren and let you hear really directly from this next generation of talent who's going to talk about, the future of privacy and AI litigation as we're seeing it emerge. So very briefly today, our agenda is as shown on the page. One thing that I think differentiates the presentation you're going to hear today from some of the presentations you hear on the topic of AI or on the topic of privacy and cybersecurity litigation is that we're going to be giving you our perspective as litigators, as trial lawyers. So this is going to be different from what you hear from pre-litigation counselors. We're going to be talking about how these cases are actually and actively being litigated and won in state and federal courts across the country. And so you'll get a sense of what's working on the ground, so to speak. Here, we can go to the next slide. So the big story, and the reason we decided to revamp this presentation this year is the big story we've been seeing over the last 2 to 3 years is this, we've had a huge increase, obviously, in privacy and cybersecurity litigation around the country, but particularly here in California and in the Northern District of California in particular. And then the big story here is, in addition to this explosive growth in privacy and cybersecurity litigation, we're seeing a huge, exponential growth in the number of cases we're seeing involving AI and generative AI, and that's, I think, unsurprising. Where we're seeing the most significant volume and the greatest increase is here in the Northern District of California, which accounts for roughly 30% of both generative AI litigation, but also of privacy and cybersecurity litigation. And again, that shouldn't be surprising given, the tech-centric nature of our district. We're also doing cases and have seen cases. We're going to talk about this in particular with Biometrics in the Northern District of Illinois. And we're seeing cases in the Central District of California and in the Southern District of New York. But the concentration, the overwhelming concentration of those cases is right here in the Northern District. Let's go to the next slide. So the big theme, one of the things we talk about a lot here at KVP, and one of the big themes I think in this space right now is we're dealing, and this has been a theme really for internet privacy litigation generally, but it's an even more extreme theme, I think, or more fitting theme when we're talking about AI and generative AI, which is the theme of we have old statutes and very new technology. So we're dealing with statutes that plainly were not written with either the internet in mind or much less artificial intelligence. So the biggest, among the statutes that we're going to talk about today is, one that everybody's familiar with, which is the California Invasion of Privacy Act. That's a 1967 statute. We're also going to talk a little bit about Federal Wiretap Act, which is of the same era, 1968. And both of those statutes were really written with very different concerns in mind. So what they were written with in mind when you talk about unauthorized wiretapping and eavesdropping is, the physical tapping of telephone lines, the placing of bugs under telephones, et cetera. What they weren't focused on is the idea that, are the type of litigation you're seeing in courts today about pixels and so forth. And they certainly weren't focused on the idea that that courts or individuals might consider certain forms of technology to be third-party listeners. So the idea that as some plaintiffs are arguing in various courts, that AI itself could be a third party as opposed to a tool, and that's the fundamental philosophical question that many of these cases revolve around, but which is really not only not addressed in the statutory frameworks, but was not even remotely contemplated by the legislatures as they were passing these statutes. We'll talk about some of the other statutes in the space are not quite as old, but also, really predate both the idea that they would be applied to the internet or to AI. The VPPA is a great example of that. It's the Video Privacy Protection Act. We're seeing those cases increasingly sought to be applied both to internet providers generally and also to in the artificial intelligence space. And so there's a big question there. I mean, a bill that was essentially passed to make sure that your video store clerk wouldn't give away the list of videotapes you had rented. This was after Robert Bork's rental history was given to the press. This was passed in 1998. Certainly wasn't contemplated that litigants would be seeking to apply that to streaming videos, et cetera, these different kinds of services. But we're seeing courts now struggle with, how should these old statutes be applied to these new technologies? So next slide. So we're seeing a variety of claims as litigants and courts are wrestling with this. We're seeing a variety of different types of claims working their way through the court. So we're seeing, different types of AI chatbots, et cetera, being, accused of being wiretappers or eavesdroppers. We're seeing a lot of litigation around the question of whether the introduction of AI requires some separate form of consent. And then obviously we're seeing a whole variety of claims around what AI may do with data and how it may redefine what personal data means when you have huge amounts of aggregate data that exists in the internet ecosystem. So the big question here for companies, I think, and for courts and litigators is what guidance are we getting from the legislatures? We just talked about the fact that we have old statutes and new technology that those statutes were not written to address. And the long and short of the answer is that legislatures have been very slow, certainly at the federal level and national level, to fill that vacuum, to provide guidance to companies, to provide guidance who are building these products, to provide guidance to the courts, and to provide guidance to regulators and litigants who are seeking to police abuses. The big beautiful bill, as it was termed, there was talk of it imposing a moratorium on state regulation of AI. That fell short. There's a new framework, legislative framework that the current administration is beginning to discuss with some calls for Congress to, provide incremental protections around parental tools, et cetera. I think and there's some recent, I mean, there is California, maybe the one exception to this, where California has done some legislation around, for example, within the CCPA, categorizing neural data as sensitive personal information, clarifying that AI-generated data may be treated as personal information for purposes of the CCPA. But more broadly speaking, what I think the industry is looking for and what the courts are looking for is broader national legislation that is going to provide guidance on some of the big philosophical questions about privacy and artificial intelligence, about the quantities of data that are being ingested, about the appropriate safeguards that need to be taken there, et cetera. And that, I think, we have not seen, certainly out of Congress, and I think not yet seen out of the states, including out of California. So I think that is something that as we look at the litigation landscape which we're going to do over the next hour, is a lot of this litigation, which is applying these old statutes to new technologies, is seeking to fill the gap that those legislatures have left open by not providing guidance to companies and the courts about um, appropriate standards for privacy in this new world. So finally, before I turn it over to Melissa and Lauren and Spencer, I guess why are we seeing, why are so many of you here today? Why are we seeing this huge explosion in litigation? Really, there's a few things driving this concern over artificial intelligence and AI beyond, I mean, in addition to kind of the general and legitimate privacy debates that are being had about those tools. One are the statutes that are being used to enforce them. So the California Invasion of Privacy Act and BIPA, which is the Biometrics Information Privacy Act, both have very significant statutory penalties. So those statutory penalties under SIPA, 5,000 per violation. Under BIPA, ranges between 1,000 and 5,000 violation, depending on negligence versus recklessness or intentionality. But on a class-wide basis, when we look at the way most of these cases are being litigated, which is either as class actions or as regulatory investigations by state's attorney general or the FTC, the penalties, at least the theoretical penalties, and we'll talk more about why, the many ways in which these cases are being successfully defended, but the theoretical penalties are very significant in these matters. And so rightfully, the courts and companies are concerned about them, and that's part of what's driving this huge spike in case filings. So let me turn it over to Spencer.
Thanks, Ben, very much. I'm going to talk today about eavesdropping and wiretapping and what we're seeing in the cases we're litigating as AI becomes the focus of some of these cases applying old laws to this new area. So first, I'll talk about some of the common causes of action, then give a few examples, and conclude with how we're winning these cases here at KVP and in other places. So common causes of action. I think as Ben was mentioning, the focus of the plaintiff's bar, starting with the internet privacy cases and now moving into those cases where they involve AI, have been the statutory tools available to them under both federal and state law. Taking the state first, we have the California Invasion of Privacy Act, as Ben mentioned, enacted almost 60 years ago and designed to protect against bugs being placed in phones, telephone wires being tapped, things like that. There's also the Federal Wiretap Act enacted a year later that protects against those similar types the similar types of alleged intrusions. We're also seeing cases involving the Stored Communications Act, the CFAA, and California's analog, which is the CDAFA. Those statutory privacy and wiretapping claims are sometimes complemented by consumer claims. Many of you will be familiar with the California's UCL and CLRA and FAL, which sometimes accompany the statutory privacy claims that we mentioned, in addition to common law claims like common law fraud, unjust enrichment, and breach of contract. Finally, a third category we're seeing accompanying the statutory claims are common law privacy claims based on the Constitution, often under California's Constitution, and then other common law claims like intrusion upon seclusion under California law. We've also seen Nevada law, Nevada common law claims like these asserted as well. And obviously, the focus of the plaintiff's bar has been in this first category for the reasons Ben mentioned, the potential of statutory damages quickly being racked up, based on, for example, SIPA's $5,000 statutory damages per violation, which with a potential class or even on an individual basis, damages theoretically reaching high amounts. So we're going to focus first on SIPA today. Ben gave some of this background already, so I'll go through it a little bit quickly. SIPA was enacted in 1967. Provisions have been added over time, but the main focus of this statute was to protect against things like you're seeing here, physical bugs being placed in phones, physical telephone wires being tapped, being wiretapped. And plaintiffs have attempted to wield SIPA in different ways in this era of internet litigation. Many of you will be familiar with the ad tech cases involving things like pixels and tags that are commonly deployed on websites. Also, a focus of these lawsuits involves location information when it's collected via your mobile phone using applications on the phone or cookies when you're browsing the internet. What we're seeing now is these cases are morphing into the AI sphere, often involving companies' use of AI for chatbots or to run their customer service phone lines in their contact centers. As I said, most of modern SIPA law has developed in the location and ad tech cases. These are two of our cases that we successfully defeated early on, and we want to talk about what worked in both of those situations. So in the Hammerling case, which originated in the Northern District of California and eventually moved up to the Ninth Circuit, we at the district court won a motion to dismiss based on a pleading attack that later was affirmed based on the privacy policy that Google had. So plaintiffs here had alleged that Google tracked the in-app activity of third-party apps on Android operating systems. They brought a number of claims, most of the claims that I mentioned on the previous slide, SIPA claims, claims under California common law and California consumer statutes. At the motion to dismiss phase in the district court, we prevailed by attacking the elements of each of those claims. The court agreed that several of those claims had pleading deficiencies. Plaintiffs went up on appeal, and the Ninth Circuit affirmed on the basis of Google's privacy policy, which it said was a complete defense to all of these claims. We argued that the privacy policy disclosed what information was going to be collected and the manner in which the collection was going to occur. And the Ninth Circuit agreed with our argument that based on the plaintiff's agreement to those terms when they were using these applications using the Android operating system, that the users had consented to the activity that Google was conducting. We think this case illustrates the importance of having broad and thorough and clear privacy policies to which users agree when they create accounts or use your services, use your website services that disclose the activity that's occurring. And this can be a broad and complete defense to a number of these claims that we're talking about today. The other thing that has worked for us, as I mentioned at the district court in Hammerling, was precise pleading attacks to each of the claims and arguments that the activity that's being alleged does not meet statutory requirements or isn't covered by the statutes here. This fits in with the theme, these are old laws that were developed to protect against things that are different than artificial intelligence or the internet ad technology is performing. So in this Google location history case, the plaintiffs alleged that Google was tracking users' locations through their mobile devices. We obtained dismissal based on the plaintiff's failure to meet statutory requirements. The SIPA Section 637.7 claim that was at issue here required the use of a device and that it be an electronic tracking device that was attached to a vehicle or other movable thing. We successfully attacked those allegations, and the court agreed with our arguments that the software services on these mobile devices did not qualify under the statutory definition of a device, and that they also weren't electronic tracking devices that were attached to anything that was movable. This is just one example of how you can defeat a claim with a precise pleading attack. It's worked in a number of our other cases involving ad technology, attacking other forms of SIPA claims and the common law claims we've discussed on similar grounds. These same techniques can successfully defeat AI-related claims as well. These are two recent cases that involved similar pleading attack strategies and were dismissed under exceptions to the statute or on failure to adequately state claims under these statutes that involved an AI flavor. We wanted to talk about just two of them. The first is Esparza from the Central District of California last year. Again, successfully defeated the case on a motion to dismiss by invoking the party exception. Here, the allegations involved Charter Communications using a third party's AI chatbot on its customer service website. Again, a SIPA claim at issue here. The court dismissed based on the party exception, which states that a party to the communication cannot be wiretapping or eavesdropping on the communication because it is a participant in the communication that's occurring. The court held here that the AI chatbot itself was a participant to the communication rather than a third-party eavesdropper. Similar issue in the Cody versus Ring case out of the Northern District. Again, a precise pleading attack worked here. Ring was accused of using a third party to administer its chatbot. The different allegations here, as distinguished from Esparza, were that that third party received the chats and used the data to train its AI models. Again, a SIPA claim at issue, and Ring prevailed based on a pleading attack, lack of plausible allegations of in-transit interception, which is a requirement for the SIPA claims at issue. And the court also found, like in Esparza, that the party exception applied to customer, which was the third-party vendor of the AI chatbot. I think both of these cases illustrate a theme Ben was discussing earlier, which is this philosophical question that the courts are facing about whether AI chatbots in these instances are participants in the conversation, tools that third parties use, or third-party eavesdroppers. And in these two cases, the courts agreed with the arguments that the defendants brought that these AI chatbots were either participants or relevant parties covered by the party exception and doctrine to these conversations, such that SIPA liability was not appropriate. Quickly, a case study that we're going to go over here involves voice AI cases. This is an area that we're actively litigating now, in which plaintiffs are attempting to apply SIPA to the use of software in call centers. This software is used to assist businesses in fielding their customer service inquiries and often involves alleged use of some form of artificial intelligence to help the customers conduct real-time analysis of the content of those calls, of customer moods and customer responses to the help that they're receiving. We're seeing a number of these cases being brought, and we're actively litigating two of them. The first one I'm going to talk about today is the Freund case, which was brought against Dialpad in the Santa Clara Superior Court last year. We successfully brought a demurrer that was sustained by the court to the first amended complaint that on the basis of the telephone company exemption, which states under SIPA section 631B that telephone companies are exempt from SIPA liability where the service that they're alleged to have provided is um, is part of like the manner of providing the telephone company's services to the third party. So, think about the software that's being used as call centers as helping the customer in a way that is equivalent to the telephone companies providing the type of services that a telephone company provides. And here the allegations were that the Dialpad AI call center software was eavesdropping on the calls that third parties like Warby Parker or Netflix were providing through their customer service sites. And again, two SIPA claims at issue here. And Dialpad's AI services were found to be exempt under the telephone company exemption. Dialpad, as a voice over IP provider, has been found to qualify for the telephone company exemption, and the court agreed with our argument, sustaining our demur to the first amended complaint that the services that we're providing were covered by this telephone company exemption. Similarly, another case involving the telephone company exemption, a slightly different flavor, is the Ambrose v. Google case, started a few years ago in the Northern District of California and is still going on now. Google there obtained a successful dismissal of the claims, which alleged that its cloud contact center AI software eavesdropped on calls, ironically made to Verizon's customer service lines. The court there found that Google was covered by the telephone company exemption in a different way than Dialpad was. Dialpad itself was the telephone company at issue in the Freund case. Here in the Ambrose case, the court found that Google was covered by the exemption because Verizon was the telephone company and Google was acting as Verizon's agent when Verizon was using this cloud contact center AI software. We think both of these cases illustrate that the telephone company exemption can be a powerful tool to defeat these cases early here on demur and on motions to dismiss. And that defense is available both to telephone companies themselves, like Dialpad, voice over IP providers, but also to software companies that are acting as the agent of a telephone company, here, Google acting as the agent of Verizon. These types of exemptions, the party exception or the telephone company exemption, are being applied in these cases to defeat these cases early before any discovery occurs. We've had success there, and we recommend pursuing these strategies early on. So I want to wrap up by giving a playbook for addressing these cases. Obviously, our strategy is to win early before discovery. We've had success on a number of cases in a number of ways in defeating these cases early. First, on motions to dismiss, for making all of the arguments I mentioned before about challenging the outdated statutory elements, arguing these cases don't apply to these situations, making arguments based on user consent to privacy policies, terms of services, lack of criminal intent based on our clients' agreements with the third parties who are utilizing their technology to not use that technology in certain ways or not transmit certain types of information. Additionally, we can't forget if you have motions to compel arbitration available to you to cut off class liability and move these disputes into private forums if they even continue to be pursued at that point, whether it's in your first party contract with a plaintiff or by taking advantage of doctrines like third party beneficiary or equitable estoppel doctrines to take advantage of the arbitration agreements that your customers have with the plaintiffs. Those are the two mechanisms we've had success with in winning these cases early. We think it's really important to build an early consent and intent record. As I mentioned, submit your terms of service, privacy policy, any usage restrictions you have with your customers to first bolster your consent argument on these motions to dismiss, defeat conclusory allegations of intent, and at the very least, frame the dispute early in terms of your robust disclosures of the activity that is occurring here. Finally, challenge statutory applications at the very outset. argue for application of the party exception doctrine. If you're able to make in these voice AI cases arguments about the telephone company exemption, also um, a robust way of getting out of these cases early. And then in addition to challenging statutory elements, targeting pleading deficiencies about in-transit requirements, device definitions, and all of the elements of the claims that are being brought. We've had success defeating these cases early, and we think following this strategy is a roadmap for doing that. I'll hand it over to Lauren next to discuss the biometrics cases.
Thanks, Spencer. So we are going to shift to talking about biometrics, which is one of the busiest categories of AI-related privacy litigation. So just at a high level, AI is expanding the number of ways companies can both collect and process biometric data. And then plaintiffs are using that expansion to push biometric claims into more and more contexts. So we'll discuss litigation trends, look at a few case studies to see what worked, what didn't work, and finish with a practical defense strategy. Ben mentioned at the very beginning the Illinois Biometric Information Privacy Act, BIPA. This is the legal foundation for this section. BIPA was passed in 2008, but it's still the main statute everyone thinks about in this space. It sets standards for how companies handle Illinois consumers' biometric information, and it prohibits selling or otherwise profiting off of that information. It provides categories for what counts as covered biometric data. You can see those categories on the right. And these cases will often turn on whether the challenge data is actually biometric data as defined under the statute. So most of these biometric AI cases fall under a couple of categories. The facial and voice recognition AI cases are fairly self-explanatory. The behavioral analysis and performance monitoring is interesting. The image on the right is actually from the complaint in a case called Cornell v. Brinks. This was a 2024 Northern District of Illinois case, and it involved smart drive technology that would scan drivers' faces, and then it would conduct facial mapping to identify driver risks and dangerous driving behavior, such as drowsiness. The next category is surveillance and monitoring. This is a slightly different flavor because it doesn't necessarily infer anything about behavior. Think sort of checking in at the gym with your face or clocking into work, that sort of thing. And then finally, we're seeing a lot of litigation about virtual try-on software that will capture facial geometry, usually for sunglasses. I think Ray-Ban and Warby Parker both have this. Spencer, we lost our slides. Okay, we can go to the next slide, please. So before we dive into specific cases, I just want to note that BIPA was making such a splash with high damages numbers that there was an August 2024 amendment to limit recovery to at most one recovery per person when the collection is done by the same method. So this stops plaintiffs from trying to count every single scan or every interaction as a separate violation. The amendment also expands the meaning of written release to include an electronic signature, which is great news for defendants, gives a clearer path to document consent. So with that, let's turn to two cases to see what worked at two different stages in the case life cycle. Starting off with a motion to dismiss in GT v. Samsung. Samsung devices come pre-installed with a gallery application, which Samsung designs and owns. The app uses proprietary facial recognition technology to scan images and then search for faces. If the app detects a face, it will analyze the face's unique facial geometry to then create a face template. The result is that pictures with specific people's faces are stacked together on the app. So what can we learn here? The motion to dismiss successfully argued 1, no possession. BIPA Section 15A applies only to private entities in possession of biometrics. So the court acknowledged that Samsung controls the app and the technology, but it still found that it doesn't necessarily follow that this control gives Samsung dominion over the biometrics generated from this app, and that the plaintiffs did not allege that Samsung actually receives or even could receive such data. Number 2, no collection. Section 15B requires the plaintiff to allege that the defendant collects, captures, or otherwise obtains a person's biometrics. Here, Samsung successfully argued, and the court found that plaintiffs didn't actually allege that Samsung receives the data the app accumulates, or that Samsung had access to it, or that Samsung even took any active step in gaining control over the biometrics, which doomed this 15B claim. Finally, Samsung argued successfully that the information wasn't even subject to BIPA. We looked at those covered categories on an earlier slide, and the allegation here was only that the app groups unidentified faces together, and then it's the user who has the option to add names to the faces. So this was therefore not biometric data under BIPA because it wasn't capable of identifying an individual. Similar facts and similar approach in Zelmer, but this time on a motion for summary judgment. Facebook uses a similar face signatures photo suggestion technology where Facebook will analyze whether the user's Facebook friends are in the user's photo and then suggest that the user will tag the friend in that photo. So here Meta used a project manager's declaration as technical evidence that these face signatures that Facebook uses, again, couldn't actually identify individuals. The face signatures were just strings of numbers representing an image of a face, did not reveal geometric information, could not be reverse engineered, and neither saved nor stored after the final stage of the tag suggestions process. As a result, this didn't count as biometric identification information as defined by BIPA, and the Ninth Circuit affirmed the grant of summary judgment. So here, I just want to briefly note that BIPA gets the most attention by far still, but it's definitely not the only biometric game in town these days. Texas has the Capture or Use of Biometric Identifier Act, QB, which requires consent for capture of biometric identifiers for a commercial purpose. Note here, though, that the Texas Attorney General has exclusive authority to enforce and hand out civil penalties. Washington State has the My Health, My Data Act, which took effect in 2024. This one focuses just on consumer health data, including biometric data, and it has both Attorney General enforcement and a private right of action. New York City also has a local law to regulate collection and use of biometric data within the city. This was enacted 2021. It applies to every commercial establishment within the city, and businesses must place a clear notice right when you walk in, notifying customers that their biometric information is being collected. The businesses also can't sell or otherwise profit from this information, and there is a private right of action available with statutory damages. So the point here is just that the biometric risk is spreading across jurisdictions, and the enforcement mechanisms and the exposure all differ. So as far as how to successfully litigate these cases, you'll want to consider a few things. As an initial matter, we should always look to see if there's an option to enforce an arbitration clause, both to get the case just out of court and then to also defeat class leverage. Next, extraterritoriality. The idea here is to build facts showing that the conduct didn't occur primarily and substantially in the relevant geographic region. The exact requirements are going to differ for each statute, but for BIPA in particular, this argument can be really powerful. There was a 2024 Northern District of California case, Vance v. Google, where Google got a BIPA complaint dismissed because the plaintiffs did not allege that Google ever interacted with them or any other person or entity in Illinois to obtain the data set at issue. Next, consent. The business needs to inform the subject in writing that the biometric information is being collected and for what purpose, and then a written release is required. So a lot of these cases will turn on whether the company gave clear disclosures, which means defendants will want to look closely at agreements, notices, acknowledgments, written policies, and any sort of consent flow. Finally, you always want to consider attacking the plaintiff's premise that the information is actually biometric information covered under any of these statutes. This is often the core fight, as we talked about earlier, both in the Samsung and the Meta face tagging cases. And with that, I will turn it over to Melissa to talk about data security.
Thanks, Lauren. As Lauren mentioned, I'm going to move our presentation forward and talk about our third set of claims today, which is going to be data security. Before we move into the content here, I just want to contextualize this part of the presentation a little bit, because when we think about the life cycle of data security, there's really three key points. There's the preparation to prevent a data breach. There's the data breach itself and the incident response. And then the third part of the life cycle is the fallout, whatever that might look like. And in many cases, it looks like litigation. So we're coming to you with our trial attorney hats on. So we're going to focus on this last piece of the life cycle today. We'll talk about litigation risks and trends. We'll look at some ways that AI is changing the landscape. We'll look at a few case studies, and we'll end with our defense playbook for data security. So starting from the top, just thinking about what do these data security lawsuits look like? Okay, so a data breach has occurred. You are working on mitigation. You might be working with forensic and cybersecurity experts, and then the lawsuits start coming. So what exactly are those? They can be enforcement actions by regulators. We're seeing this both inside and outside of the US. And then, of course, within the US, we are seeing differences in the kinds of claims, the kinds of damages and penalties available at the federal and the state levels. In addition to enforcement actions, a big piece of this data security litigation are class actions, which come from private right of actions, from privacy statutes and laws, which often we will see get consolidated in this multi-district litigation. Because when we are seeing these lawsuits pop up in sometimes multiple fora, it becomes really unwieldy to deal with them on a case-by-case basis. And so it's sort of in the interest of all the stakeholders involved, the plaintiffs, the defendants, as well as the courts, to consolidate these lawsuits into an MDL. And then, of course, the third category that we are seeing, it does happen, is criminal liability at the individual level related to the mishandling of security obligations. So the big kind of landmark case for this was USA versus Sullivan back in 2018, where the Uber chief security officer, Joseph Sullivan, had attempted to cover up a data breach and was actually found guilty of obstruction of justice. And so, that's a good lesson learned, where we're not just talking about civil liability when it comes to data security, but we're also talking about ensuring that we are thinking carefully when these breaches happen, so that within the company, employees and executives are following their legal obligations to avoid that personal criminal liability. So moving on to talk a little bit about how AI has changed things in data security. This is, as with all things related to AI, I think it's a bad news, good news situation. So start with the bad news first. AI is causing an increase in data security breaches and follow-on litigation. So now we are seeing 1 in 6 breaches involving AI-driven attacks. 97% of organizations that are experiencing these breaches are reporting that it is in some way due to lack of proper AI access controls and integration. And so let's talk about why that's happening. And there's lots of reasons why, and we're just going to kind of talk about the 3 main reasons today. The first is just weaponization of AI tools by bad actors. This is not anything novel. It's just there's been bad actors in the past. There will continue to be bad actors in the future. And now they just have a whole host of new tools that are available to them in the form of AI. The second is that companies who are using AI and integrating AI have AI products. They can just be new vectors for data breach attacks. Some examples of this are we're seeing this happen via prompt manipulation. Another example, embedding a poisoned data into data training sets. And so the use of AI in some ways are making companies just more vulnerable to data breach. And then the third category here, which hopefully we can all learn to avoid and mitigate this one over time, is the misuse or unauthorized use of AI tools within a company. So this is where you want to think about what AI licenses are you using in your company, what AI tools are your employees relying on, and are they doing so in a way that is authorized in compliance with the license, in compliance with your company policies? Are there good trainings available to make sure that employees are using the tools in the way that they should be? So for example, depending on the kind of license that you might be using, not putting confidential information into a chatbot, things like that, to avoid being taken advantage of by a hacker. Before we move on from this slide, I do kind of want to just highlight that there is a good news story to AI when it comes to data breach and data security, which is that companies that are using AI are integrating AI into how they're thinking about data security are actually seeing cost savings when it comes to data breach. So in 2025, the global average cost of a data breach was $4.4 million. And taking that as kind of the starting point, the companies that had been using AI within their security protocols and practices, they saw about a $1.9 million cost savings. So this is, again, when we're thinking about AI, we want to think about the risk, but we also want to think about how we can use this technology to our benefit. So moving on to talk about a few case studies. We're going to talk about three cases today. The first 2 are going to be cases that are sort of emblematic of the issues that come up in these data security cases, kind of the themes that really come to the surface in this litigation. And then the third case is we'll talk about a defendant that was using an AI product and experienced a data breach. So this first case, Greenstein versus Nobler, the focus of this case was really on standing. So this was a leading data breach case in 2024 that went up to the Ninth Circuit, where the issue before the court was a pleading attack on standing. The issue and the allegations were that general notice had gone out to plaintiffs or to individuals who had their data exposed in a breach. And then a group of these plaintiffs came together to sue Nobler, the company that had experienced the breach. But the allegations were very broad. They were very speculative. They weren't able to actually allege certain harm or damages. And in many ways, they weren't even able to get past the allegation with respect to the general notice. So the general notice was communicating to plaintiffs, we had this data breach, your data's been exposed, but plaintiffs weren't able to get beyond that to show that their data was actually being used in any way that could even cause harm. So launching a strong standing attack at the pleading stage was a really effective tool for Nobler here. And you can see on the right side of this slide, this is a quote from the Ninth Circuit opinion, where the court is focused on this speculative chain of possibilities, which was not enough to get plaintiffs past the pleading stage. The second case study I want to talk about today is a great case study on privilege. So this is the In Re Samsung case that came out of the District of New Jersey in 2024. And privilege is not necessarily something that is unique to data security because it does come up disproportionately in data security because, as you may know, or as you know may seem logical, when it comes to a data security case, there's lots of players involved. It's not just the in-house attorneys within the company, it's not just the outside attorneys, but it's a whole host of other data experts who are working on figuring out what happened, working on mitigation, communicating to consumers and customers who may have had their data impacted by the breach. And a lot of these players are not attorneys. And so there's a real question of privilege that comes up. Oftentimes, the framework that we see is that the in-house folks will sort of be taking the lead of the show. They will involve the outside attorneys, and then outside attorneys will take it upon themselves to hire those outside third-party vendors, the forensic experts, the cybersecurity firms, and the outside counsel will sort of, to kind of create some separation between the company, will work with those third-party experts and will assert privilege, will often assert attorney work product over a lot of what the vendors end up creating to help inform the company, both on exactly what happened in the data security breach, how to prevent another one moving forward, what notice requirements and obligations they may be under, and then of course, risk of litigation and potentially even work product that's going to help advise on that litigation. What we see in the District of New Jersey case is the court really taking a laser focus to the documents that Samsung was attempting to assert privilege over. And instead of making a blanket decision or order that they were all privileged or that they were not privileged, the court actually conducted an in-camera review, took the individual pieces, the individual documents that the plaintiffs were looking for in discovery, and conducting a review based on factors that the court had put together by doing a really in-depth survey on privilege in data security cases from across federal district courts. It's a really good opinion, again, not just for data security, but any time in litigation where we sort of see this framework of in-house counsel, outside counsel, and then third-party experts. And what the court ended up doing was saying that in some cases, the privilege applied to the third-party expert work, and in some cases it didn't. And the big takeaway here is this quote on the right-hand side of the slide, the mere delegation of certain business functions to attorney is not enough to establish strong privilege and work product grounds. So last case study today is sort of notable in that it's not notable. This ServiceAid is an AI company, and they experienced a data breach. And we are sort of seeing like a run-of-the-mill data security lawsuit come out of it. We have the sort of typical causes of action on the left that you may expect. We see the typical dismissal arguments, including lack of standing, lack of duty of care, lack of causation. And I think what this case is really emblematic of is that AI service providers, AI companies, AI-based products are not going to be exempt from this data security litigation. So ending here with the defense playbook, a little bit we've heard, a bit of this we've heard earlier in Spencer and Lauren's presentations. We've also kind of seen these themes come out in the case studies, but just putting it all together here, these are sort of the big pieces. When that data breach happens, we are immediately thinking about how to prepare for potential lawsuits. We're thinking about Are we preserving evidence to avoid any potential arguments of spoliation or improper destruction of evidence? Are we going about privilege the right way, as we saw in the Samsung case? Are we managing MDLs in the right way? Are we seeking that out? And if that is being held up for any reason, are we seeking stays in the cases that are pending? Are we right from the get-go putting together our early motion attacks to challenge injury, to challenge the elements or the lack of allegations for the elements that are required for these causes of action, notably lack of causation and lack of damages. And then finally, right from the beginning, even though class cert doesn't necessarily come up right at the beginning of the lawsuit, but at the beginning, making sure that we are preparing for that motion to defeat class cert, which class cert is very difficult in the data security context because the individual customers and consumers whose data may be affected, they're often affected and impacted in different ways. And so it's important to think early on, how can we differentiate among the members of the plaintiff's class here? Are there different laws at issue based on where the plaintiffs reside? Is it for some of them, was it just their data was involved in the breach, and for others, their data was actually used in nefarious ways? A lot of the times, this is where experts are really valuable and important. And so thinking through those class cert arguments early on can really benefit you if and when you reach that stage of the case. And I'll turn it over to Ben just to talk briefly, because I think we're about at time, of overall strategy takeaways here.
Yeah, thanks, Melissa. And I'll be very, very brief because I know we're pretty much at time here. I think the big takeaway here is that we try here at KVP because we're fundamentally trial lawyers and litigators. We try to think about these cases from the very beginning about what are how are we going to argue this if we had to argue this to a jury, and try to build those themes into our early dispositive motions, which is where we want to obviously kill these cases before they get going. And if you think about what the themes here are, in the typical theme, right, we're talking about, and you've seen this in what Spencer and Melissa and Lauren have described, but we like to focus early on this issue of consent and disclosure, to explain that the product that's been built and the data that's been collected is giving consumers exactly what they signed up for and what they understood based on the privacy policies and disclosures. We like to focus on the important and good work that the technology companies are doing, how that work helps consumers, and the fact that those companies are building this technology responsibly, and so building the story about their privacy protections that they're building into those products, and why those are responsible and industry standard protections. We like to talk a lot about this big theme of today, which is these old laws, new tech, and explaining why these 1960s era statutes really are a bad mismatch for the kind of philosophical privacy questions that are being posed today, and why while those are important questions, they're just not the questions that these wiretapping and biometric statutes were designed to address. And then finally, we like to talk about, and again, this is a little bit of a philosophical defense, but as a theme, the understanding that as human-like as AI seems, it is fundamentally a technological tool, and that automation is not the same as having a third-party eavesdropper. And so those are there's others, but those are some of the themes that we like to emphasize in these early motions. And the goal always is to try to get dismissal of these cases as quickly as possible, because as Melissa and Lauren and Spencer alluded to, we have great defenses throughout the life cycle of the case. We have great defenses at summary judgment. We have great strategies around class certification, but we are also very appreciative of the cost of litigation of getting a case to that phase. And so our goal is usually is always really to get rid of these cases as early and as quickly as we can. And I think we're now at time, although, and I'll defer to Amy if we don't have time for this, but if there's one or two questions, we're happy to take a minute or two there.
We can take a couple questions if anyone has one and wants to drop one in the chat. Otherwise, we'll move to some breakout rooms and get set up for the next program.
Great. Well, seeing no questions, thank you all. And like I said at the very beginning, this is a revamped version of this presentation to really talk about this new wave of AI litigation that we're seeing in the privacy and cybersecurity space. If you have feedback for us, if you have questions you'd like to see us address next year, shoot us an email, and we'll look forward to hearing from you. Thanks a lot.